Good evening. This meeting will come to order. This is Zoning Board of Appeals, Milford, November 2023 meeting. Let's begin with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Roll call, please.
Mr. Smith and Mr. Wolf are excused. Mr. Dubois?
Here.
Ms. Ferrante?
Here.
Ms. Hirsch?
Here.
Mr. Montano?
Here.
Mr. Soda?
Here.
And Chairman Tazzola.
Here. Also present this evening are Stephen Harris, our zoning officer, Meg Green, our recording secretary, Mr. Dubois. Mr. Wolf is not here this evening, so you will fill in for him, please. Okay, thank you. Let's see. If you're here for number one this evening, Westport, 72 Westport Place, that's been moved to December. If you feel there's a member on this board, there's a conflict of interest to your application, please let us know. Other than that, Ms. Secretary.
Item number 2, 11 Mont Street, MBP 70/739/40, R5. Brenda Kurtopoulos, agent for Anna Del Franco, owner, varies section 3.1.4.1, front yard setback to 2 feet where 8 feet required, to convert porch to living space. Vary 4.1.4, rear yard projection to 3.5 feet where 16 feet permitted, to construct rear porch/steps. Survey by J. Codispoti, dated 9/7/23.
Hi, everybody. So you've...
Just try and talk right into that microphone, if you would, please. Lift it up a little bit. Identify yourself and your address, please.
Okay. Brenda Kurtopoulos, representing Anna T. Del Franco of 11 Mont Street. So the applicant purchased 11 Mont Street on August 23rd, 1988. This 0.11 acre R5 zoned property was built in 1955. At an unknown time, the enclosed porch was added. Ms. Del Franco purchased the home with the enclosed porch. As mentioned, tonight there's 2 variances that I'm requesting. This is an existing non-conforming building lot with respect to multiple reasons, including lot size, but for today's meeting, we're addressing the front and rear pre-existing non-conforming setbacks. The first is the applicant respectfully seeks a variance to section 3141, the front yard setback, to 2 feet to where 8 is required to convert an existing enclosed porch to living space. The variance requested is essentially to repair and renovate in a form in the exact location of an existing enclosed porch. The proposed design remains within the original 176 square feet footprint. The height will also remain the same. And the proposed that's shown on the survey, and also you should have construction drawings representing the design as submitted to zoning. Understanding the reasoning for the necessary variance and the fact that the proposal increases the conditioned living space, the proposal does not seek to change the footprint or position of the front yard setbacks of the existing. The existing footings will be used and the front entrance will remain the same. As to work within the existing footprint and the interior layout, repairing and then renovating the enclosed porch, opening it up to the main house appears to be the best way to work within the parameters of the existing non-conforming setbacks. The same front yard setback would exist as of right regardless, even if the change was not made. Again, understanding the reasoning behind the necessity of a variance in meeting the required setback, There's no undue hardship to any neighbor in terms of pressuring their property with regard to any setback. The repair modification should not impose a negative impact and stay consistent with the scale of the neighborhood. To my knowledge, there's been no neighbor to oppose the renovation. I'm only aware of those in favor. Emails from the residents at Fremont, 58 Village, and 51 Village Street. So that was in reference to variance number 1. Do you want me, does anybody have questions, or should I go on to number 2?
Are you all done with your presentation? Well, I'll ask and see if there's any.
For the first one, for the first variance, there's 2.
Oh,
Front yard setback.
all right. Any questions for this applicant? You're all set with your presentation, correct?
No, I just want to
Okay,
just quickly,
okay.
the
Go
second one is
Go ahead, you can
is
finish
fast.
that.
And then the second variance is for the rear yard setback in regard to section 414, the projection of 3.5 where 16 is permitted. This repair will actually decrease the nonconformity by 72 square feet by removing the existing deck and repairing and rebuilding existing steps. The steps are a necessity to exit the rear of the house. And again, it's a repair of what's there and removing a deck, so decreasing the nonconformity.
Okay, thank you. So pretty much, I mean, the front space is always what it's been. It was an open porch.
It's not,
And there's
it's
no
actually
changes.
enclosed.
There's no changes at all. It's just going to be enclosed.
It already is enclosed, it's just not conditioned and open to the house. So it's enclosed with windows, just not conditioned, and it's not open to the house. There's a door between the existing porch into the home. We are going to open the porch into the home and condition it, so it will then become living space, but the footprint of the house will not change.
Okay, thank you. Any questions? No? No other questions right now? Okay, Mr. Soda, when did you want to ask that?
Stephen, I have a question for you. Because that's an enclosed porch with windows already, why does it need a variance?
The enclosed porch is a projection off the house. Once you open it up to the building, it becomes part of the living space. It's part of the building now. It's not a projection.
Are we all set? Okay. All right. Is there anyone else speaking in favor? Anyone else speaking in favor of this application? Is there anyone here opposed? Anyone opposed? Any further questions for the applicant? None? Okay. This hearing's closed. Okay, we need a motion.
I move to approve the request to vary section 4.1.4 rear yard projection to 3.5 feet or 16 feet permitted to construct rear porch/steps, survey by J. Codispoti dated 9/7/23.
She's all set. We need a second.
Oh, I second the motion.
Okay. All right. Okay. We have a motion to approve and we have a second. Discussion.
I have no problem with this application. As far as some of the applications we get, this is a very reasonable renovation. It's not increasing the footprint, and she's taking off the porch. It's a tight lot, and it's a decrease to the nonconformity, in my opinion.
All right. Any other thoughts or discussion?
I completely agree with Sarah on everything.
Okay. No further discussion? Mr. Dubois?
With the motion.
Mr. Montano?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Soda?
With the motion.
I'm with the motion, it's approved.
Item number 3, 185 Rogers Avenue, MBP 36/416/12, R5, John and Claudia Lynch, owners, vary section 3.1.4.1, side yard setback to 2.6 feet where 5 feet required for addition. Survey by R. Plain, dated 3/4/22, revised 10/17/23.
Good evening, folks. John Lynch, residing at 185 Rogers Avenue. We presently live in a one-story, 840-square-foot house with the 290-square-foot addition. We're hoping to bring the kitchen or dining room up to the main level and also provide a new entry to the house. This will be removing the existing 8x12 front porch and the front stair. By doing so, we will only be extending the existing house an additional 10 feet past the existing porch. We are asking for a side yard variance to extend the existing north side yard of the existing house 18 feet toward the front of the property. Thank you for your consideration on our variance request. Thank you.
Your question?
How many square feet did you say the addition is?
290.
The side yard setback right now is, it is 2.6, isn't it, Mr. Harris? Is this a continuation here on this?
Yes, the existing side yard setback is 2.9 in the back, if you look on the map where the cursor's going around, and it's slightly closer here. It's like it's following the wall, the existing wall, out like that.
Thank you. Any questions? Is there anyone else here speaking in favor? Anyone else here speaking in favor? Anyone here opposed? Commissioners, any more questions? Go ahead,
Good evening.
Good evening.
I don't see it listed in your application. I may have missed it in your presentation. What is the legal hardship that you're claiming?
I don't know that there's a legal hardship. We just want to extend the house a little further than its current footprint. In terms of legal ramifications, I don't know of any. Thank you.
any further questions? Okay. All right, this hearing is closed. We'll have an answer for you right away, sir.
Thank you, sir. Thank you.
I move to approve the request to vary section 3.1.4.1, side yard setback to 2.6 feet where 5 feet required for addition. Survey by R. Plain dated 3/4/22, revised 10/17/23.
I second.
We have a motion to approve, and we have a second on the motion. Discussion?
I think that this is, well, I know that this is an undersized lot. It does have a much greater depth than minimum required for the zone, and he is proposing, he's making use of that depth by putting the addition on the front of the house, not asking for a front yard variance, not asking for a side yard variance, because of the narrowness of the lot, which is below minimum for the zone. You can't help but require a side yard setback variance, and it's in line with the existing house, so I feel okay with this.
Any others?
I feel the same. It's a narrower lot. It's 40 feet in the front and 30 in the back? It's pretty narrow.
Okay. Any other discussion? Okay. Take a vote. Mr. Soto?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Montana?
With the motion.
Mr. Dubois?
With the motion.
I'm also with the motion. It's approved.
Item number 4, 46 Marshall Street, MBP 63/934/11, R18, Established Contractors, LLC, owner. Vary section 3.1.4.1, side yard setback to 9.75 feet, where 15 feet required for addition. Survey by F. D'Amico, 10/19/23.
How you doing? I'm Willie McAllister of 46 Marshall. What I'm asking for is the back right corner. It's approximately-
Did you identify yourself?
Yes, Willie McAllister
Okay.
for 46 Marshall Street. So on the back right corner, I'm looking to, the setbacks now are 15 feet, and we're approximately 9.75 feet from the property line. I want to add 5 feet by 12 feet in the setbacks to extend the master bedroom to make it more cohesive with the neighborhood and everything else that's in that area, and just kind of make it more functional. So.
Simple as that.
Yeah,
Okay.
it's small.
Any questions for this gentleman?
I have a question. This is the proposed building or the existing building?
That's the
Oh,
proposed.
that's the addition in the back. Okay.
Yes.
Perfect. Okay, thank you.
Anyone else speaking in favor? Anyone opposed? No further questions? Okay, this hearing is closed.
I move to approve the request to vary section 3.1.4.1, side yard setback to 9.75 feet where 15 feet required for addition. Survey by F. D'Amico, 10/19/23.
I second.
We have a motion to approve. We have a second on the motion. Discussion?
Like the previous application, this addition is going in line with the existing house, and it's modest. I'm okay with it.
Any others? No? Okay. All right, Mr. Dubois?
With the motion.
Mr. Montana?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Soto?
With the motion.
I'm with the motion. It's approved.
Item number 5, 187 to 189 Hillside Avenue, MBP 59/795/69, Kevin Kersaden Esquire for, R5 zone, Kevin Kersaden Esquire for S. Anand, owner. Appeal the decision of the zoning enforcement officer and chief ZEO in accordance with the provisions of section 9.2.1 regarding 10/3/23 decision to revoke two-family certificate of zoning compliance.
Good evening. For the record, my name is Kevin Kersaden. My office is at 3 Lafayette Street here in Milford, Kersaden and Moore. I'll be relatively brief. I'm going to go over just mention some of the exhibits and including the affidavit that we filed on the land records recently that have a lot of the same exhibits, and discuss the case law a little bit and talk about the difficulty in determining intent, which is why the statute was revised a few years ago. So this property, I've used the Sanborn maps. I've gone back to the original property map. I think it was 1895 or 1899, had 2 houses on it. For, I think, over 100 years, up till 2016, it had 2 houses. And then after that, I think actually one of the houses was demolished in 1963, but thereafter, it continued as a 2-family use in one of the structures. Stevens presented or given some of the tax cards, and some of the tax cards are also with my application. So the critical thing here is that Connecticut General Statute 8-2 was revised a few years ago, and I included as one of the exhibits an email from one of the gentlemen who was involved in that lobbying for that revision to clarify when a pre-existing non-conforming use is abandoned. And in this case, there has to be an affirmative intent to permanently abandon the use and no evidence and an affirmative intent not to also reestablish that use. So basically, in this particular case, we start off with 2 houses, it's 1 lot. It's been like that since Milford probably started taxing structures. It's been taxed, it's still taxed as 2-family as of today. So when the previous 2-family house was demolished in 2016 and it was replaced by a single-family structure with an accessory unit, it continued on with the 2 property addresses, 187, 189 Hillside, and it continues to be taxed as double occupancy or 2 occupancy, meaning 2 dwelling units. So I'll just talk briefly about the former CEO of Home Builders and Remodels Association, who had sent an email out to a planning and zoning listserv a few years ago explaining the reasoning behind the change in the statute. There was a clear intent, and I'm quoting his email to that listserv, on their part, meaning the part of the legislators, that even a long lapse of time without any other evidence of an intent to abandon is not enough to lose your right to rebuild the nonconformity. And in this case, it's the 2-family use. It's not necessarily 2 single-family houses, but it's the 2-family use on that 1 lot. It's a pro-property rights thing, and he goes on to say that, sometimes new laws change existing ways of doing things. I'll go briefly through the evidence. One of the things that was confusing, that in September of this year, Stephen issued a zoning compliance review that agreed that it was a 2-family and that was zoning compliant. My client purchased it as a 2-family. It was listed in the MLS as a 2-family. He thought it was a 2-family. I do some zoning work for Mr. Anand. He had contacted me to talk about the rear property line because the border on Long Island Sound had changed over the years. So I was involved working on that, but he had never even given a thought that it would no longer be a 2-family, seeing as how it's taxed as a 2-family and it has 2 legal addresses. So that never came up as part of our discussion when we were figuring out the new legal description based on the survey. It came up after he had already purchased the property. And I want to talk about Connecticut General Statutes 8-2 as revised. It says specifically, and this was the revision, such regulations shall not provide for the termination of any nonconforming use solely as a result of non-use for a specified period of time without regard to the intent of the property owner to maintain that use. Such regulations shall not terminate or deem abandoned a nonconforming use, building or structure, unless the property owner of such use, building, or structure voluntarily discontinues it, and such discontinuance, and this is the important part, is accompanied by an intent to not reestablish such use, building, or structure. And the demolition or destruction of a nonconforming use, building, or structure shall not by itself be evidence of such property owner's intent to not reestablish such use, building, or structure. So after we received the initial zoning compliance, when Mr. Anand made a permit to rehab the house and expand the existing accessory dwelling unit into more square footage as a 2-family, the initial zoning compliance review was it was compliant as a 2-family, and then thereafter I received an email or a decision or a determination from Mr. Griffith that it's demolished because, that's been abandoned because that structure's been demolished, which goes directly against what the statute represents. And this is the problem overall with any statutes or regulations that have to do with intent, with respect to land use applications anyway. It's a similar problem that the city had with 642, where Stephen would be put on the spot with, I think that the owner's intent was to merge these lots, and as evidence of that, I see a swimming pool or a trampoline or what have you. The problem is that it's one person in one period of time that's determining the intent. So in this particular case, it was Mr. Griffith's single determination that this use was no longer a two-family use. Mr. Griffith could retire in a year or two, and somebody else could come in and have a totally different opinion. That's why the statute was changed. So there has to be, what should be there is something that the homeowner puts on the land records, and I think Stephen's asked people in the past to do this. I'm permanently abandoning this use, whether it goes in the zoning file or whether it goes in the land records. And in this particular case, Mr. Anand has a title search done. He's looking at the property for other reasons. He has a survey. There's nothing in any of the records that say, hey, this property that is taxed as a two-family, has two legal addresses, that's no longer a two-family. There's nothing there to indicate that. So that's, I think, a problem for the city, and I think it's a problem with this decision. Respectfully to Stephen and Mr. Griffith, I disagree, but if you read through the affidavit, I'm not going to read line by line. It goes back to, like I said, I think the earliest subdivision map that we could find was 1906, where it was two families. It goes all the way up. I looked at the Sanborn maps, which are the previous fire insurance maps, have it as either two houses or two families. Stephen originally made the determination it was a two-family. You know, the Connecticut General Statutes supports this argument that unless there was something affirmative in the records, on the land records or in the zoning file, or the applicant or the previous owner made a public statement. But I don't think we can infer intent to a property owner in 2016 who is getting a coastal site plan for a single-family house with an accessory unit. They're still being taxed as two-family for that number of years. They still have two legal addresses. There's no evidence in here that that person knew that they were forever foregoing a two-family use. And it was advertised and sold as a two-family use on MLS. So I'm available for any questions about this. Stephen did give me a copy of his memorandum for this evening. I noticed that it doesn't mention the fact that it's taxed as a two-family or that it has an accessory dwelling unit. It just has a single-family dwelling. I don't think that accessory dwelling units typically get their own separate address. I think it's the same address and it's the same set of utilities usually. So, you know, we'd ask that you respectfully, I'd ask that you overturn this decision by the zoning enforcement officer, and I added chief zoning enforcement officer because I originally got an email decision from Joe on this, and then a new zoning compliance review was issued that said two-family use, you know, non-compliant. It's a real issue when a person purchases it thinking it's one thing, and he's pretty experienced developer at this point, and there was nothing in the record to indicate it wasn't a two-family. So it is a property rights issue. I don't have any other further comments unless you have any questions for me. Thank you.
Yeah, we have a few questions.
Okay.
I'll ask you one question anyway.
Sure.
How many years was this used as a single-family house?
Well, it was a single family with an accessory dwelling unit since 2016. So not just strictly single family.
And there's a new owner right now?
Yes, Mr. Anand's here with me tonight.
Okay.
Yeah.
Okay. Go ahead, Ms. Ferranti.
So the two-family was demolished in 2016 in favor of a single-family with an accessory
Right.
unit.
Right.
And Mr. Griffith says, well, now you're pointing to a 2018 regulation that says abandonment alone is not suitable for, demolition alone is not suitable for determining abandonment of use. But was that the case or was that not the case in 2016? Was demolishment sufficient in 2016 to determine abandonment?
So the reason they revised the statute is I think that it was unclear, that there wasn't clear case law, and they were probably getting different results in, you know, different situations. So, but that 2018 statute, because it applies to pre-existing legal non-conforming uses, would apply retroactively back to 2016 or 2010 or what have you, because it's designed to talk about legal pre-existing non-conforming uses. That's the whole purpose of that section of 8-2. So in 2016, it wasn't, oh, you abandon it, you're done. In 2016, it just wasn't, the statute wasn't as clear as what it is, post 2018. It didn't say, the statute at that point in time, prior to 2018, didn't say if you abandon it, you're done. It had some other, similar language, but this language spelled it out and clarified it a little bit more.
So in 2016, it was up for interpretation, and it could have been interpreted the way Mr. Griffith did? I mean, if you demolish a two-family house and build a single-family house,
Well,
couldn't that be interpreted as abandoning the two-family use? You're
Not-
not using the property in that way anymore.
not based on this statute, but I will say one other thing about it. It maintained two addresses, and it was continued to be taxed as two-family.
Yes.
So that individual wouldn't necessarily, I would agree to a certain extent, maybe not 100%, but I could see if it was a single family, there was a letter in the file from the property owner that said, I'm going back to a single family, and please approve this project. The two addresses go down to one address, two sets of utilities go down to one set of utilities, that type of thing. And it's taxed as a single family from that point on. I think you would have more of an argument than in this case.
No, I definitely agree that the two addresses is kind of a fly in the ointment, so to speak. Does the property maintain two sets of utilities?
I don't know under the current construction, but not right now. So it's under one set of utilities, yeah.
Mr. Soto.
Sarah asked almost all the questions I was going to ask you, but, so anyway, what you're saying is, if you demo a house, that's not, so if you demo a house, you still have to provide a letter or something in the file that says, I'm going back to a single-family use.
I think, Mr. Soto, it's just beyond, if you look at it, if you remember a few years ago, people would leave one wall of an existing house up because they didn't want to lose that pre-existing non-conforming setback.
Right.
So that was for the structure, but this is a similar thing where people don't do that anymore, not in Milford anyway.
Right.
There's some people that have been building in Milford or practicing in Milford a long time that still think that that's required. Oh, don't demo that house, you need to keep at least one of the walls up and then build around it. That doesn't apply anymore. So because they've determined that just because you demolish something doesn't mean that you're giving up that non-conforming setback or you're giving up that non-conforming use.
Well, see, I would think that the minute you demoed it and then you built a single-family house, you're giving up that use of a two-family. And since you have single utilities there, you don't have 2 meters and you don't, 2 gas meters and all that. It's basically a single-family with an auxiliary apartment in it.
Well, it's
like an in-law apartment or something.
It was approved in 2016 as a single family with an accessory apartment, but it continues to be taxed as a two-family, and it continues
Well, that
with
might
the
be
two
just a mistake on the tax department.
Well, but it also continues with the two property addresses. But now, respectfully, we're trying to go, when you're trying to determine intent, you're trying to determine what was in somebody's mind. And from these set of facts, I don't think one person should make the determination that that demolishing that, or that there's evidence in the file just because they demolished that. If I'm continuing to pay taxes as a two-family for the next 7 years, and I have 2 different addresses, I don't know where the evidence is in the file that person voluntarily discontinued that use. Maybe they voluntarily discontinued that use, but there's no evidence in the file that they of an intent to never reestablish that use. And in fact, they marketed it on MLS as a two-family and sold it as a two-family. So they're not, in this particular case, I would argue if someone came to me with a single family and there was nothing in the file based on this statute that use was abandoned, as a two-family and it went down to a single family, I would make the same arguments. But in this particular case, the set of facts are stronger because of the continued taxing, and also because that person might say, oh, well, I'm paying taxes as a two-family, because a lot of folks don't understand the fact that the tax assessor is different from the zoning, and they think because they have, they're taxed as a three-family that they have a legal zoning two-family. A lot of people don't understand that. So when you're talking about somebody's intent, we're talking about this gentleman's intent and all the previous property owners. And it was a two-family use on that property since at least 1905 or 1906. And it's continued on. 2016 to now still has 2 dwelling units on there. It's got an accessory dwelling unit, and it's got a, the single-family structure. So in this particular case, I don't think the facts support abandoning it based on that statute and the facts.
Would you happen to know how many families have lived at this property for how many years? And I guess no one's had a problem at all paying extra taxes for a two-family versus a single?
Well, I know that, I think the previous property owners bought it, and I don't know if it was, I'd have to look at the tax history or the land records. I know that, I think for 7 to 10 years, the previous property owner lived there, or they at least owned it. I don't know whether they lived there or not. And then prior to that, I don't know who was living at the residence.
And we don't know, of course, there's no way of telling if 187 was used as a mail address or 189, or, one of them had to be used all the time and the other one was probably just sitting there, unless it was being used as a two-family.
Well, I'm pretty sure up until 2016, the structure was a two-family house. Whether they were both occupied or what the mailing addresses were, I'm not sure. I do have a historical researcher that I could find out I could try to see if she could find out that information.
Well, I realize I'm asking that is a tough question, but it certainly would tell us who's at 187, who's at 189. Has there been somebody there? For all the research that you have done, I'm sure that's something that would have been, really have a difficult. I'm asking the question, but that would show a lot if we actually knew the answer.
Yeah, unfortunately, I don't have that information. It's a good question.
Any other questions? Ms. Ferranti?
If we assume that the previous owners who demolished and rebuilt in 2016 did not intend to abandon the two-family use, then why was the new structure classified as a single-family home with an auxiliary unit instead of a two-family home if it was, in reality, 2 dwelling units?
So it's a good question. My guess could be as good as yours, or not as good, or just different. And the important part is that it's a different guess, because I don't know what their conversation was when they went down and either talked to Stephen or his predecessor, whoever was there at the time, and said, I'm going to do this, and I just want to do this at this point in time. And they say, okay, well, file this application. I mean, I think that going back to that statute, a lot of what that statute is designed to do is eliminate Kevin's guess versus Ms. Ferrante's guess versus Joe Griffith's guess. So let's make it clear. Let's have something affirmative in the file to say that this use was abandoned with an intent not to, to permanently abandon it or not reestablish it. Because, I don't know if these people were savvy developers or this was their home and, oh, well, we'll do it this way, and what difference does it make? We're just going to use it this way because, somebody's mother-in-law is going to live next door, or the kids are going to live next door, or whatever the situation was going to be, not knowing what that impact would be. But it's interesting to me that the when Mr. Anand bought it, and he does do his due diligence, you know, was listed as two-family in the MLS, which is not gospel, but at least from the previous owner's intent, which I think those previous owners were the same ones that that did the work. I'm not 100%, I think it is. I think the previous owners were the ones who applied for that new house.
Yeah, Mr. Soto, go ahead.
Attorney Crusade, here's the problem I'm having. If you built a house in 2016 and it was a two-family with the cost of utilities, I really think they would have put separate meters in. And I think it was kind of like a red flag to your client when he was buying it that there weren't separate meters. I mean, you know, if you're advertising it as two-family, but you only have one set of meters, that would give me a red flag, like, let me look into this a little bit further. Because I'll tell you right now, with the cost of utilities, you want those split. You know what I mean? You know, just because of, you know, keep your costs down as a rental unit. You know what I mean?
Yeah.
So I got one other scenario here.
Okay.
If it was a two-family house prior to, and they tore it down, and they built a single family without the apartment, would that have abandoned the use?
No.
Under the new statute, or do
No.
they still have to put it in writing?
I think that there has to be something in writing to say we voluntarily discontinued this, or something paraphrased
I
along
mean-
these lines, and we have no intention of reestablishing this use. And so why would somebody do that? Somebody could do that because they are asking for, you know, a larger structure or a larger footprint. I mean, there could be other reasons why people decide to give up a two-family use or put it on the land records. Mr. Anand had somebody over at 14 Crest Place. I did the work. I had a historical researcher. I forget the person who lived there, but it was someone who survived a famous shipwreck. It was one of the original houses in Morningside, and we found out that it was actually a two-family. Provided the information to Stephen. He agreed with us. Then right after that, the person that Mr. Anand was selling it to said, I don't want it as a two-family, remove that. And so he went back and changed the permit, and he had conversations with Stephen. I don't know if Stephen asked him to put anything in writing, if there was email exchange, but it says specifically in that permit, reduction of density to single family. When that work was done, because that buyer, that prospective homeowner, wanted it that way for whatever reason. They didn't want it listed as a two-family or known as a two-family. So that's a further point I forgot to bring up. Mr. Anand has been on the other side of this, where he's had the same conversations with the Planning and Zoning Board, where they've said, or excuse me, with the Planning and Zoning Office, where they've said, put something in writing to us that you're reducing it. That happened at 14 Crest Place. And so that permit specifically says reduction of density in it. So that's his experience. That was a year or two ago. Then he comes and he sees this house. There's nothing in the records that specifically say that, so he considers it to be a two-family.
How long had the one at Crest been a two-family, and then how long was it a single family?
It was I think one of the oldest houses in Morningside. I think 1899. It was a two-family for a number of years, and then it had been, I don't know if it had been divided up into different sections, but it was a number of years.
And then it became a single family,
But
then he
for
went
ex-
back
but-
to a two-family?
But for example, up until that point, for I don't know how many years up until that point, let me just ask my client. So it had two kitchens when he purchased it, but the zoning office had it as a single family. And so we had to do some research with the Sanborn maps, the fire insurance maps, and some other research in order to prove that it was a two-family at the time, because that was what Mr. Anand was going to sell it as until he got a buyer that said, I want it as a single family. So when that happened, his experience with this type of issue was that something needs to be affirmatively stated to the zoning office so there's a record that you're reducing the two-family down to the single family, which is what he did for Crest Place about a year and a half ago. But as far as the utilities, Mr. Soto, and I know you're experienced with construction and you've been on the board a number of years, but the comment I have in response to what your concern, your red flag about the utilities is, I don't know what the utilities would have cost to replace, two sets of utilities. I don't know what their thought was. I don't know what the cost of utilities was in 2016. So I still think that in fairness to general property owners, not just Mr. Anand, but something should be clear in the record other than it's more of a passive application. If the coastal site plan application said, we're giving up the two-family, we're going to do it a single family with an accessory unit, please approve it, then we wouldn't be here. But it doesn't say anything like that. So I think we're kind of guessing, we're going back and guessing to try to figure out why people took certain actions back then without any clear indication.
Any other questions? All right.
Right, okay. I just briefly, Mr. Anand was bringing up that he has some three families and other things in New Haven, and there are three families, but they do it on 1 meter because of the cost of utilities. So I don't know if the utilities must be included in the rent. So there's that aspect of it too. Thank you.
All right. Is there anyone else speaking on this appeal? Do you want to talk, sir? No, I think. Okay.
No.
All right.
Thank you.
All right. Anyone else speaking on this appeal?
Yes, me.
Okay. Mr. Harris.
Good evening. Stephen Harris, Zoning Enforcement Officer. I'd like to read the city's statement, position statement into the record. So, summary of facts and procedural history. The 1948 field cards show a two-family dwelling on this lot. This non-conforming use continued until 2016. On 3/1/16, a special permit and coastal site plan was approved to construct a single-family dwelling. The house was built and has been lived in. A new owner purchased the lot 6/26/23 and applied to revert to the previous two-family use. On 9/25/23, a certificate of zoning compliance was issued for a two-family. On 10/3/23, the certificate of zoning compliance for the two-family was revoked. The city's position is, after further consultation amongst the planning and zoning staff, the department reversed the decision to issue the CZC for a two-family use. The department felt that since a one-family house was constructed, the owner showed intent to abandon the prior two-family use. In reaching its decision, the department relied upon section 6.2.7.1 of the zoning regulations, which reads, the term abandonment as used herein shall mean the voluntary discontinuance of a use when accompanied by an intent not to reestablish such use. Any one of the following shall constitute prima facie evidence of intent to abandon. And subsection 1 reads, any failure to take all necessary steps to resume the non-conforming use with a reasonable dispatch in the circumstances, including advertising of the property for sale or for lease. So in conclusion, the department finds the construction of a one-family dwelling shows intent to abandon the prior two-family dwelling. I'll be happy to answer any questions.
Okay, questions for Mr. Harris? Go ahead, Ms. Ferranti.
Do you have was that included in our materials, or is there a printout where I can reread some of that?
What was that?
Can you put your statement on the screen?
Sure.
Thank you.
Yeah, let's get a little closer.
Go ahead, Ms. Ferranti.
Is this saying that advertising the property for sale as a two-family is or is not a necessary step to resume the non-conforming use?
Well, there are several criteria in the regulations, Milford's regulations, that speak to intent. This parentheses number 1 was the evidence of intent that applied here.
Intent to resume the non-conforming use?
Yes, there's several criteria that the Milford zoning regulations include that would show intent.
So,
This is
so
the-
why did the office revoke the decision?
Well, we had discussions among staff, and the staff felt that since the two-family was replaced by a single-family and has been lived in, it's the department's opinion that that showed intent to abandon the two-family. When you take down the two-family, build a one-family, and you're living in it.
I understand, but I do think it's fair to say it wasn't merely a single-family home, it was a single-family home with an auxiliary dwelling unit.
It was a single-family home with an accessory dwelling unit, which is still a single-family home. An accessory dwelling unit is not a second apartment in the normal sense of the term. It's accessory to the single-family.
I understand that, but the average homeowner might not when applying to reconstruct their home.
So Stephen, you're saying the voluntary discontinuance of the use was established when they decided to build a single-family house?
Yes,
Okay.
the department feels that shows intent to
I
abandon.
kind of agree with that. I mean, if you tear something down and you go from a two-family to a single-family, you're giving up the right to have a two-family. I mean, now that they're saying the law says you have to, what do you know about this law that says you have to put it in writing that you're discontinuing the use?
Well, that's Attorney Corsiden's position. It's not ours.
Go ahead, Ms. Hirsch.
Thank you, Mr. Chair. So Stephen, just piggybacking off of Ms. Bronte and Mr. Soda's questions, when the 2016 permit was approved for the single-family property, the city has determined that that was the moment that the two-family dwelling became a one-family dwelling.
Yes,
Okay.
that's what they applied for.
And that was what the Joe Griffith indicated was the intent to
That's
not
what the
reestablish.
the department's position is when you replace your two-family, it was a storm-damaged house, and you build a single-family, that shows intent to get rid of the two-family.
Understood, but the statute, the CGS statute that Attorney Kersadian provided indicates that demolition alone does not evidence intent to abandon and not reestablish.
Well, the language that says demolition alone was added to 8.2 after this house was approved.
Agreed, in 2018, I believe.
Yeah.
But it wasn't,
then-
it wasn't
but then-
demolition alone.
Right, but then the same owner that applied for that 2016 permit to create a single family with the accessory dwelling marketed the property for sale as still a two-family lot. So doesn't that remove the intent that Mr. Griffith thinks the homeowner had at the time of that 2016 application?
Well, when we reach this stage, intent has to be, somebody has to decide what intent is.
Right.
So in the state we're in right now, it's the department's position that replacing the two-family with a single-family, building it and living in it, shows intent to abandon the two-family.
Forever. Because that's the argument, right, is that
Yeah.
it can never be reestablished. Once it's abandoned, it is no longer.
Once it's abandoned, it can never be reestablished.
Okay, thank you.
And The statute says demolition alone, but it wasn't demolition alone, it was demolition and reconstruction of a single family.
Is that a statement or a question?
Well, that was kind of a statement.
All right, Ms. Ferranti? No? Anyone else? Any other comments? All right, Mr. Harris, you're all set with your presentation. We have no more questions for Mr. Harris? Okay, it's all yours, Mr. Crusaden.
I don't know, I'm sorry, Mr. Harris, can you pull that back up? There's a couple of different ways to look at it, but what we're doing is now we're talking about what was somebody's intent in 2016 without really knowing, and he brought up any failure to take any necessary steps to resume the non-conforming use, including advertising of the property for sale or for lease, okay? The property was a two-family use for over 115 years, or 110 years. So for it to be a single-family use for 6 or 7 years, or a single-family use, why didn't the homeowners call down to the tax office and say, hey, why am I paying taxes on 2 units? I'm only 1 unit. So that, to me, indicates that that homeowner didn't think that they were 1 unit. They thought that they still had the two-family use. Also, it's, once again, with the 2 addresses continued on there. So I think that most property owners that I know, unless they're trying to preserve some property right, I've had other clients in the past who will specifically not call the tax assessor and say, don't assess me as a building lot, because they want to build on that lot again in the future, and they're afraid by going to the tax assessor that they won't be able to do it. So that's a commonly held belief as well. If you look at the sheer year, if you just did it by a year percentage, for 7 years, it was a single-family house with a accessory dwelling unit, taxed as a two-family with 2 addresses, and then for 110 years before that, it was two-family use. So if you look at it that way, what's the intent there? Just because it was demolished? The statute and the reasoning behind changing the statute specifically says demolishing is not the intention, is not evidence of an intent never to reestablish it. I'm not the only one who interprets the statute this way. I put affidavits on land records for clients if they're changing uses. We have the conversation now because of this statute, and I do a CGS 8-2 affidavit and put it on the land records. Hey, don't abandon that, use that you have, and we'll work it out and we'll record it. I've seen other attorneys that I have had no contact with that are doing similar things. So people understand that they want to make sure that these uses are not lost. And in this case, I think that the use was never intended to be lost, and so they marketed it and tried to sell it that way. So thank you.
Attorney Crusaden, can I ask you a question still?
Yeah, you can.
Okay,
It's still
so
open.
with what you just said, back to that scenario, if it's a two-family house, they tear it down, they build a one-family, but at the time they put on the land records that they're not abandoning the two-family use, and they built a single family, is that use still there?
I think so. That's why I do the affidavit since that statute's come out. That statute, as Ms. Ferranti pointed out, didn't exist in 2016, but I advise people all the time, including, and I do it for lots, whatever somebody might be afraid, and I'll tell people, be careful if you call the assessor, because even though the assessor in zoning, it doesn't really necessarily, the assessor's office doesn't inform whether something's a legal zoning use, but people, when they take all of the evidence into consideration, they consider that evidence too. And I've had boards, I think it was this board with Myers Lane, where one of the reasons for denying their variance was that she had called down because she had paid taxes on it as a building lot for 15 or 20 years, and she finally couldn't afford to do it because they had some financial issues, and they called and changed it. And then one of the comments from this board was, well, you changed it, so you must not have thought it was a building lot. So I think in this case, if I was paying taxes on a two-family and I didn't intend it to be a two-family, I would call the assessor and say, I'm not paying, why are you charging me for, two-family? So, Thank you.
All right, we have no other questions? None? Okay. Mr. Harris, you're all set? Okay. All right, this hearing is closed. Okay, so we've talked about this, and the decision is going to be to either uphold or overturn.
Mr. Chairman, I have a question. Can you clarify voting for or against the appellate?
Depends on how the motion.
Okay?
As the motion stands now,
As the motion stands now,
if you're in favor
There is no
of...
motion yet.
we don't, whatever the motion
I'm sorry.
happens to,
To be stated.
whatever the motion happens to be,
Oh.
it's going to be the majority like always.
Okay. Thank you.
The majority on either way, so, okay. All right. So we have to start with a motion.
I move to overturn the decision of the zoning enforcement officer in accordance with the provisions of Section 9.2.1 regarding 10-323 decision to revoke the two-family certificate of zoning compliance.
Seconded.
All right, we have a motion to overturn, and we have a second on the motion. Discussion?
I think that this has been a very interesting and lively debate, and there is evidence to show intent to abandon, and there is evidence to show intent to maintain non-conforming use. It is up to interpretation, but I believe that there is more evidence to show intention to maintain the two-family use of the property. I think that the average homeowner, even when going through something like a demolition and a rebuild, doesn't necessarily know all the definitions and all the terms that we use so frequently here. And I think that building a single-family home with an auxiliary unit at the onset shows intent to maintain two dwellings. It's marketed as a two-family home on the MLS. They maintain two addresses with the tax department. I think that you can make arguments against this, but I think more overwhelmingly in favor of what I'm saying.
Other comments?
Well, I agree with her that there's evidence for both, and I'm leaning towards the two-family use because I think there's more on that side too, but it's a tough one.
Mr. Montana?
I support the motion.
To clarify, Mr. Chairman, if we vote in favor of the motion, then we are voting in favor of the appellant and overturning the decision. Okay, just to clarify.
Any other discussion, any other comments? Okay, we have a motion to overturn, and we have a second on the motion. Mr. Soda?
I'm with the motion.
Ms. Franti?
With the motion.
Mr. Montana?
With the motion.
Mr. Dubois?
With the motion.
I'm with the motion also. Okay, what do we have? New business? Any new business? Any old business? None? None? All right. I believe, Meg, you sent the minutes from last month. Everyone looked through those? Any additions or corrections on them? None? Okay.
Can I just
What
jump
are the-
in with
Sure.
a very tiny staff report? I just am so proud of this board because you are pretty well completely trained. and in time, well ahead of the January deadline, so you're doing better than PNC.
What other business do we have? Anything else? Motion to adjourn? Okay, this meeting is adjourned.